We're on the record in case 24 CRI 226, caption State of Ohio versus Robert Prater. Here for purposes of a bond setting on a complaint that was filed earlier today. The defendant is present. We are conducting this hearing by video. Hearing on behalf of the State of Ohio's prosecuting attorney, Christopher Tennell. Mr. Prater, did you get a copy of the complaint that was filed?
Yes, ma'am.
Did you have any objection to the court conducting this hearing by video?
Say it again.
Do you have any objection to the court conducting the hearing by video?
No, ma'am.
Court has to go over the complaint with you. There's one count in it. Count one is complicity in the commission of an offense, a felony of the second degree. It reads on or about July 24th, 2024 in Ashland County, Ohio. Robert Prater did act with the kind of culpability required for the commission of an offense and did aid or abet another in committing the offense of robbery, Ohio Revised Code 291102A2, and the underlying offense was a felony of the second degree, to wit, aid and abetted Carrie Stevens and or James Phipps and or Sir Rogers and or Taquan Thompson to commit robbery at Rite Aid, 419 Claremont Avenue, Ashland, Ohio, in violation of Revised Code Section 292303A2, 292303F, complicity in the commission of offense, a felony of the second degree. Do you understand what the state is alleging in that complaint?
For the most part, yes, ma'am.
Right. Do you have any questions about what the allegations are? You don't have to agree with them, just so you understand what they're saying you did.
Yes.
All right. You have certain rights in this matter. First, you have the right to remain silent. Anything you say during the course of this hearing could be used against you at future hearings. You have the right to have an attorney, and you have the right to a court-appointed attorney if you cannot afford to hire your own, and if you qualify. There is a $25 fee for court-appointed counsel. You have the right to have a preliminary hearing. That's a hearing where the state must establish probable cause as to the complaint. And you have the right to have a jury trial and to have the state prove your guilt beyond a reasonable doubt to all 12 jurors. Do you understand those rights as I've explained them to you?
Yes, ma'am.
Do you want to be represented by an attorney?
Yes, ma'am.
Can you afford to hire one, or you want me to consider you for court-appointed counsel?
Court appointed. I can't afford one.
Just have a few questions for you to see if you qualify. We'll find you do qualify for court-appointed counsel. The court's going to appoint Attorney Donald Wick to represent you. We'll let him know he's been appointed, and he'll be here for you at the next hearing.
Okay.
We are going to address the matter of bond. The court's going to let the state of Ohio go first, and then I'll ask you if you have anything to say for bond if you want to. So, Attorney Tennell, the state's position on bond.
Thank you, Your Honor. Your Honor, the court should be advised that on July 24th, this defendant and four co-defendants, all from the Dayton, Montgomery County area, arrived at the Rite Aid store on Claremont Avenue in the city of Ashland. This defendant and two of the co-defendants went in while the other two waited in the car. This defendant and the co-defendants inside the store were wearing masks. They came back to the pharmacy area of the store, at which time they entered the separately secured area of the pharmacy. One of the employees was shoved to the ground, and they demanded that the pharmacist open the safe. He did so at their request, and they then cleaned out the safe, pills and assorted medications, and then fled to the waiting vehicle, where they were pursued by law enforcement from the city of Ashland, Ashland County, and the Ohio State Highway Patrol. That pursuit went from the city limits of Ashland to I-270 in the Columbus area, and it stopped because they ran out of gas. The court should also be advised that the state has been in contact with authorities from the state of Pennsylvania. It appears that this is not an isolated incident, but is part of a wider, conspiracy, if you will. There are multiple Rite Aids in the state of Ohio that have had this occur to them, as well as the state of Pennsylvania. Pennsylvania's investigators have been here for a couple of days, trading evidence with our local law enforcement. The court should also be advised that this defendant, per Oleg, has a juvenile conviction from 2015 for robbery, a felony of the second degree. And 2022 is an adult possession of cocaine, 5, and a having weapons while under disability, third-degree felony. The state would request no contact with any Rite Aid store anywhere. No contact between the co-defendants. The court have him enroll in the court's GPS monitoring program. The court's standard conditions as part of bond, and would request 500,000 cash, surety, or real estate. Thank you.
All right, thank you, Attorney Snell. Mr. Prater, if you would like to say something regarding what the court should set for bond, you can do that now. I'll just remind you, you don't have to. So if you want to talk to your attorney first, the court can always readdress the issue of bond. Because if you recall, you do have the right to remain silent. Is there anything you want to say today regarding what the courts should set for bond?
I was thinking more like a release on GPS, because I'm not just no violent person, ma'am. I promise I'm not. Like, all of my charges, it come with like a, what word am I looking for? It come with a background, a story, because I never just physically got caught with anything. I never physically just robbed nobody or nothing. I never did nothing to nobody. The robbery was a fight turned to a robbery. Like, it was me and somebody else fighting, and they turned it into a robbery. I never just robbed nobody, ma'am. I got 2 kids at home, and ain't none of my kids over 3 years old. I got kids that I need to live for right now. I'm not really trying to hurt nobody at the moment. I wasn't trying to hurt nobody. I tried to stop it, but I couldn't stop it. It already happened.
Thank you, sir. All right, the court's going to set bond as follows. To be released, you'll have to post 2 bonds. The first is a personal recognizance bond. That's your written promise with the court to appear at all future hearings in the case. If you fail to appear, you could be charged with a separate felony offense for failing to appear. The second would be a surety bond, a bond secured by real estate or securities as allowed by law, or the deposit of cash in the amount of $250,000. Court's going to order conditions of bond that you not leave the state of Ohio without obtaining written permission from the court, appear at all future hearings in the case, and keep the court informed of your current address and telephone number at all times. Follow and obey all laws of the state of Ohio and orders of the court. Do not use, consume, or possess any drugs of abuse or alcohol, and you'll be subject to random drug and alcohol testing. Cannot use any products containing THC while you're on bond. After you post bond, you need to report to the court's bailiffs. Their office is located across the hallway from the clerk of courts. They'll get you enrolled in the court's drug testing and bond program. Court's also going to order you're subject to passive monitoring through GPS tracking, that you need to comply with all the terms and conditions associated with the GPS. Court will order that you're responsible for a daily monitoring fee at the rate of $3.25 per day. Prior to release, you need to post $250 for the GPS monitor, and then $195 for the first and last month of monitoring fees, as well as a $50 fee for screening. If you return the GPS unit in good condition, that $250 deposit will be returned to you at the end of the case. Court's also going to order you're subject to a curfew at an approved residence for 24 hours a day, 7 days a week. You may only leave that approved residence for your employment, scheduled meetings with your attorney, court proceedings in this case, and any medical appointments for yourself. The court's going to order you have no contact, whether direct or indirect, with Taquan Thompson, Sir Christian Rogers, Carrie Stevens, and James Phipps. Court's going to order that you have, you will not be on the premises of or be within 500 feet of any Rite Aid. Do you have any questions about the conditions of bond, sir?
So the 250,000 is just 250,000.
That's right, sir.
I have no question.
Okay. We're going to set a hearing, Attorney Snell, Tuesday at 2:30. Okay.
Tuesday.
Right. We're going to set this for an initial appearance next Tuesday at 2:30 p.m. If you bond out, sir, you need to come to the courthouse for that hearing. If you haven't bonded out and you're still in jail, we'll have you by video, but we'll give you a chance to talk to your attorney privately before we get started. Okay. All right. We'll see you back Tuesday at 2:30 then. Anything further, Attorney Snell?
No, ma'am.
All right. We're adjourned then. Thank you.